And I don't know where the other attorney might go against us. Court doesn't call the case, we call the case. Brand versus Logan.
Good morning again, Your Honor. John Sure. I believe my client should be on now. He had some technical difficulties.
Your Honor.
Mr. Grant?
Yeah, hi, sorry about the problem. Yep, sorry
No,
about that.
Not a problem. All right, Mr. Logan, state your name, sir.
Rodney J. Logan.
All right. Sure, I think this is your motion, is it not?
For the record, Darwin Fair on behalf of Mr. Logan.
All right. Go ahead, counsel, whoever wants to go, you guys.
It is.
You try to run your own show anyway, so I'm just here.
It is the plaintiff's motion, Your Honor. And
All right, go ahead.
we were here on January 9th, at which time I had received an answer to our motion the afternoon before the hearing. Didn't have time to reply to it. My client got the keys to the home from Mr. Logan the morning of the hearing, January 9th, and discovered that the furnace was taken from the home at that time. And there were other problems with the way the home was surrendered. Your Honor wanted an estimate or invoice for the cost to replace the furnace and other items in the property, which we have supplied with our reply to the defendant's answer. And I just got a reply to that reply yesterday afternoon, which I replied to. But essentially, Your Honor, the case.
Hold on. There's a defendant's reply to plaintiff's reply?
Yes, Your Honor.
And there's a plaintiff response to that reply that we emailed to the court.
I got you, but I'm now, hold on, I'm missing two. Because I have plaintiff's reply to defendant's answer to motion to lift stay and return escrow payments. I have that one. That's the one where there are attachments. I think that's the one that I. So my understanding is that then defendant filed a reply to that or response to that, and then you filed a response to his response.
That's right. Both of those were filed. He filed with the court yesterday afternoon.
We don't have e-file, but you said it. Do we have?
They were email.
Yeah, no, I got you. But
there were two documents that were brought down from the clerk's office first thing this morning. They should be loose in the file.
let me see there.
All
I have plaintiff's reply to defendant's answer. I have two of those.
And we did
One
one
that's dated, hang on. The one that's dated March 4th, which is yesterday, is plaintiff's reply to defendant's answer. But now then defendant files something, because that's what Mr. Fair does. And then plaintiff then files something else. I don't have either. I have two copies of Mr. Sherman's motion or reply, but I don't have anything from anything recently from Mr. Fair and then from plaintiff's counsel, which is a reply from Mr. Fair. So, what email did you use, counsel?
Your Honor, if I might explain the reason that you have two replies. The email I used, Your Honor, was
Okay, that was that's the one that you sent everything to, right?
Yes, Your Honor.
Mr. Fair, did you email yours in?
I believe my office faxed it in, Judge.
Oh, great, so now I got two places. To the court.
Yes,
Yeah.
yes.
Okay, are you,
I'm checking with the clerk's office.
And I emailed Brother Counsel a copy of my reply, so he has.
And Darwin,
Yes,
Darwin,
that's fine, I believe all of you, I just don't have it, and I'm not sure why I don't. They brought something down, but they just brought the copy of plaintiff's reply to defendant's answer. I don't have anything else.
Yeah, they're checking to see if there was anything else. The only thing they remember seeing was the stuff that you had. Carrie's the lead. Carrie.
Okay, why don't we do this? Let me pass the matter, let my staff, because I want to read what you guys have, so hopefully. I know Mr. Sheriff gets to the point, but Mr. Fair is probably gonna take me a minute, so. I didn't mean it that way.
no, read me like a book, Judge, read me like a book.
Yeah, I know, but sometimes you just get to the end of the book, then you see what it's all about. Okay, so let me find those, let me pass the matter, I apologize about this, counsel, but let me find those so that I have everything in front of me, okay, so I'll pass this matter again. You can have a seat, you come back up when I call.
I got you.
All right,
Got you.
thank you.
Thank you.
Brand versus Logan, recall.
John Sherrill appearing on behalf of the plaintiff again.
Good morning, Your Honor. And everyone. Once again,
Mr. Fair, did you state your appearance, sir?
can I hear you?
Yeah, I'm sorry. Your Honor, for the record, Darwin Fair, Rodney Logan.
All right. So counsel, go ahead with your motion.
Good morning, Your Honor. John Sherrill again on behalf of the plaintiff. And Your Honor has had this case since before you granted judgment for possession to the plaintiff on October 29th of 2021. This is the second motion for order of eviction and release of escrow funds that I have filed on behalf of the plaintiff. The first one was filed on June 28th, 2023, after the Court of Appeals affirmed the dismissal of Mr. Logan's complaint to quiet title, in which he sought to set aside the sheriff's deed on mortgage sale after foreclosure of his mortgage. In that Court of Appeals opinion of June 1, the Court of Appeals on page 6, and we attached that Court of Appeals decision to our first motion, Judge. The Court of Appeals noted that, quotes, Logan's rights in the property were extinguished when he failed to redeem the property. And the claim, Your Honor, being made by the defendant that my client is realizing a profit from the purchase of a sheriff's deed from the party who, the grantee of the sheriff's deed, is untrue, first of all, but it's really not relevant to the issues before this court. My client has been deprived of the use of the property since he purchased it, well, since the redemption period expired. In the answer to our present motion, Your Honor, the defendants, relying on a Zillow estimate of the value of the property, at $295,000. That was exhibit 1 to their answer. That same exhibit 1, Your Honor, has the Zillow estimate for the monthly rent at $2,400 a month. Your Honor entered the escrow order on January 4 of 2022, requiring Mr. Logan to pay $1,500 a month, beginning on January 1 through 2022, which he did through November of 2023. So he's paid 23 months at $1,500 a month for rent that totals, he's paid, there's an escrow amount of $34,500 according to the information I've received from your clerks. Based on the estimate provided to this court by the defendant, the fair market rental value of the property is $2,400 a month. From the date your escrow order.
Currently, it would be that.
Well, Your Honor, when your Honor entered the order, based on the hearing, we supplied a Zillow rental estimate of the same amount, $2,400 a month before your escrow order.
I know, but I don't.
But Your Honor,
I don't rely entirely on Zillow because I don't know if one can rent something for that.
But the only
I mean, they're going solely on market, not condition. So go ahead.
the point I was making, though, Your Honor, is they're relying on Zillow for the fair market value of the property. And that Zillow estimate they relied on was $2,400. Mr. Logan did not pay anything for December. And for the 24 months from the date of the order through the date that he finally surrendered possession, just 24 months at $2,400 a month would be $57,600. That's the amount of rent that my client lost since Your Honor entered the escrow order over 2 months after the court awarded possession to my client on October 29th. Whether or not that Zillow estimate is accurate, Your Honor, point is that we have not only made a profit during this appeal period, my client has lost the rental value at any amount of the property. In addition, the furnace was removed. My client has paid $39,000 plus in property taxes. He just got a water bill from the city of Ypsilanti yesterday that says that there's $613 still owed for water. And we've supplied his estimate of the cost to get the house ready to list for sale to possibly realize the $295,000. Based on his estimate, Your Honor, he would still lose $20,000. But perhaps most importantly, Your Honor, the Court of Appeals finding that Mr. Logan lost his rights in the property, they were extinguished when he failed to redeem the property, indicates that the idea that my client's making a profit has no bearing on this case whatsoever, because Mr. Logan has no rights in the property for over 3 years now. Under the circumstances, what my client did or does with the property is none of Mr. Logan's business whatsoever. The only question is whether Mr. Logan should be allowed to stay in the property after the judgment of possession, rent-free, while my client has paid the taxes on the property and been deprived of its use and of its rental value or the possibility of sale. So that's why we're asking that the entire rent escrow be released to the plaintiff. Pardon me, Your Honor.
Thanks, Your Honor. Number one, with regards to the current value of the house, we stated it is $295,200. The plaintiff has not objected to that number. So we can go with that number since there's been no objection to that. The number two, they went and stated, with quote unquote specificity, what they have lost as a result of it. And let me just say this, Judge.
Mr. Fair, why am I going through an analysis of loss on the premise? I mean, I don't, because as this case starts out, it starts out basically as a summary proceeding.
That's correct.
Right? The escrow order that I entered is based upon the court's view of the rental of the property.
That's correct.
So if it doesn't matter what the number is, it's a number that I picked based upon my estimate of what that property could go. So I set it, and your client is effectively, while you're dealing with the other litigation, renting. That's really what's happening. So I'm unclear as to, from your analysis, why I'm even through some analysis of what the property's worth, what it's not, whatever. I mean, if the property market had crashed and the property then is worth nothing, or whatever, it had gone down in value, what analysis would you then have? That he overpaid for rent? Right? But that's not what's happening.
I'll wait till you want me to respond, Judge.
Go on.
Oh, okay. Well, okay, Judge, and believe you me, I can understand the court's reasoning and thought process here. The reality of it is the interim order and escrow order, I-2, specifically says in the last sentence that I put in the motion, otherwise the court may condition disbursement as justice requires. And so you have to look at the situation as it is. I think without question, it would be a totally different situation if the value of the property had decreased during this time period. No question that would be the case. However, it has increased in value, and he has made $150,000 profit as a result of it. That's the reality, and it hasn't been disputed, other than they make reference to all these expenses they've occurred.
Why, but Mr. Fair, why am I dealing with the value of the property?
Well, the reason is, as justice requires, he has a windfall profit now. So
Yeah.
that's the only reason, Judge.
No. If that's why, Mr. Fair, I'm unclear as to what this argument is. And we get into this every time we get to the end of these cases.
Right.
Sometimes I see a point in returning some of the money that's paid. Sometimes I see a point in doing it. In this case, I'm trying to figure out where that, if I start with the analysis that for this period in time, the Logans have paid rent. That's really effectively what's been done.
That's correct.
If during the pendency of the appeal, I had said, instead of paying it to the court, that you have to pay it to the plaintiff, would we be involved in a lawsuit where your client would be suing the plaintiff for return of some of the monies because the value of the property went up?
No.
Then why am I hearing this argument in this case?
Well, Judge, I keep pointing to that paragraph as justice required. And it's an individual analysis. They wouldn't have put that sentence in there if they weren't giving the court the discretion under the circumstances as justice required. And Judge, you know, we're saying to the court, this is what justice required. And Judge, believe you me, I understand it's your call. Believe you me. And what we're doing, yeah, and Judge, no, Judge, and that's why we're laying out with the discretion of the court why justice required that Mr. Logan get the escrow back. Now, we're saying all of it. They're saying none of it. Judge, you know, you can make the call where that lies at the extremes or in the middle. But I think we've laid out our case. They have not objected to the $295,000 value of the property, which means it's $150,000 profit. Now they want to reduce expenses out of it. That's fine. I get that. But even in the worst case scenario, when you go through all the expenses, they're still making a profit of $90,000. Judge, quite frankly, I would love to be in that situation.
But hold on a second, Mr. Fair. Why am I concerned with what profit they make?
Justice requires.
Really?
Justice requires, Judge. I mean, that is the basis of our argument. It's justice. It is fairness. He's gotten a profit of $150,000. That is where justice steps in. If it was the same, the number, we couldn't make that argument. If it had been reduced, we could not make that argument.
Mr. Fair, if the plaintiff had gotten possession when I originally ordered, right? And let's say during that period of time, he just decides to hold on to it. He's not flipping the property. He's just holding on to it. And he rents the property. Let's say $1,500 a month. Right? And then we get to today. And he decides he's going to sell. He would be in the same position as he is right now. Right? I'm unclear as to why I'm taking into account that he may make some profit. I'm assuming that people get houses, hoping that will be the case. So I mean, you're asking me to penalize him because there may be this profit.
No, Judge, not to penalize him, but just to accept the reality that he's made a huge profit. I mean, I think everyone would love to be in that situation where you make a huge profit, $150,000. And of course you're going to have expenses.
But hold, okay, I get that. But Mr. Fair, let's take it from the other side.
Okay.
If during the pendency of this action, your client would have had to have rented someplace, how much would they have spent?
My client, their rent would have been what rent they would have paid, because rent is a function.
So what I'm asking is, over that period in time, how much would they have paid in rent?
If you're asking me to do the math, Judge, I can do the math. But what I will say,
okay, do the math. Because here's the problem. The problem's going to be that they would have had to have spent more in rent over this period of time than they paid into escrow.
Well, no, I'm not sure if that's true, Judge. Let me tell you why. Because you set escrow at $1,400, and I will posit to the court that is their ability to pay. So in other words, and that's what people do, Judge. They rent places based upon their ability to pay. If the court would have said $2,400, I don't know if Mr. Logan could afford that. He could afford a 1,400. If so, but you know, we're taking this hypothetical to a point of you can go so many different ways with it. But again, Judge, people
Mr. Fair, you don't like my hypothetical. That's
Okay.
because I don't like yours.
all right, okay, so
I mean, I'm just, Mr. Fair, listen, all I'm saying is you're approaching it from one end of plaintiff's profit, what plaintiff is going, where he ends up. And I say, okay, that's fine if you want to analyze it this way. But then I'm saying, you're asking well, let me back up. In plaintiff's argument, once they get through everything, taking where the plaintiff is, there's a $20,000 short. Okay? Okay, let me take that. If I take it truly from your client's side, what I would have to say is, okay, what would, over that period of time, would they have paid in rent?
well, okay, Judge, we can take that number, whatever that number is, and if you subtract it from the $90,000, they're still made a big profit.
No, I'm not why am I subtracting it from the 90?
Because that's the reality of where we
No,
are.
no, Mr. Fair, here's what the math would be. If your client paid over this period in time, let's say 35,000, we'll just round it up to 35,000. But would have over that period of time to rent something very similar. I mean, this is one of the things that would have had to pay, say, 50,000. Then the analysis in that would be your client made a windfall of about 15,000.
Well, and Judge, that's why I brought up the point. People rent at their ability to pay. That's what they rent.
No, that's not. That would be great if that's how rent works. That's not how rent works, which is why I have my docket that I have every Friday. It's not based upon somebody's ability to pay. It's what the rent is set.
Well, yeah, no, but that absolutely is what rent is set. But the flip side is, can you pay that rent or not? If you can, that's your ability to pay. And if it's too high, then you have to go look for another place. This court set it at $1,400, and my client made the payments. That's a reality. That's, Judge, that's where the justice requires comes in. It is the court taking in consideration all the facts and circumstances surrounding this issue, not taking a quote unquote, here is the analysis that we would use, but to look at the reality of where we are. And that's the only reason I'm saying about the reality is that Mr. Grand is in an excellent position right now because of him. He's got the property, and now he can make this $150,000 profit minus whatever he paid.
But Mr. Fair, you're ignoring something.
Okay.
Your clients would have had to pay something for housing expenses during that period.
That's
It's
correct.
not based upon their ability to pay. It's not going to be based upon any of that. They would have had to pay. They would have had to pay something to house themselves.
That's
That's
correct.
clear,
That's
right?
correct. That's correct.
So your analysis, you keep coming back to the plaintiff. I'm saying on your side, the analysis doesn't involve plaintiff.
Well, okay.
Your analysis has to involve what would happen to the Logan during this 2 to 3 year period of time in terms of the rent.
Okay, Judge.
Okay, now plaintiff probably didn't like the number 1,500, but it didn't go up. I mean, it didn't raise and lower itself with the market. You guys were caught in this artificial world of the real estate of Cedric. And I set the price. That's where you guys were. And so if the true market had dropped or risen, either side sort of takes a hit on it. They just do. Unless somebody comes in and asks me to increase the escrow. Nobody asked me to do that. It just stayed where it was. And so now when we come down to the end, everybody's looking for where the escrow should go. I understand the issue of what justice requires, but I also have to say, the Logans would have had to have housed themselves. It no longer becomes an issue of I'm paying on a mortgage or I'm paying part in equity. They would have had to house themselves. They would have had to, if absent buying property, they would have had to rent something. And the number I'm not seeing, I see the analysis when you're analyzing it from the plaintiff side. The analysis I'm not getting from you or from anyone. Well, I guess in a sense setting. But what would they have paid to rent? What are you saying they would have paid to rent over that same period of time?
Well, okay, good question, Judge.
3, 4, 5, figure out where it should fall. But that's the
Okay, well, no, fair enough, Judge, fair enough. So now we're looking at, was 1,400 fair? Was 24 should have been fair? Should it have been 750? I think our argument, it should have been $1,000. And I can't quite remember what the mortgage was, but having said that, Judge, we can make the argument that they could have paid a lower rent if they would have left the house, and therefore they should be entitled to the difference.
Oh, no. They're renting that property.
Correct. No,
right? So to rent something comparable from the beginning of 2022, for the 2 years plus, what would they have paid?
I can't tell you off the top of my head what that number would have been, but I do know, or my recollection was that we believe that the rent should have been $1,000. And so they've gotten the benefit of $400.
You've been before me before, so you will sometimes just get the number out of the air, we'll say. That should be paid. That's why I get to say.
Correct.
But I don't know that they would have gotten a property such as this in this market around here for $1,000 a month. It wouldn't have happened.
But it's their house, Judge. It was their house. I mean, it's not like they've always lived in there. So again, we're looking at, as justice requires, this, they could have moved.
I know, Mr. I understand they could have. But the reality is they're getting some use of the premises for that period of time. And you have the use of the premises, like with any situation where this one turns out that they weren't entitled to the premises. Really, by statute, they're renting. Because they become tenants at sufferance, in essence. Under at least one analysis. And if that happens, then what is that rental value?
Well, we can argue that, Judge. You know, they argue more. I argue less.
Mr. Fair, you want me to return a certain portion to the loan.
That's correct.
You have to give me a basis in which to do that. If you have something that says that the rent would have been, you pick out a figure of 1,000, that a rent for this premises would have been 1,000, then I need to see it.
and
I don't believe the 24. I know, yeah, Zillow comes out with whatever they're gonna come out with, but I mean, I don't believe the 24.
and I hear that.
Because I don't believe that it would have remained consistent, that the rent would have been consistent for 2 years. So,
Well, and I hear the court, you know, you've asked me a question, and so, you know, I have to go and see if I can find something tangible for this court of why the rent should have been less than what it was. And that's the court's analysis. I mean, that's fine, Judge. If that's the court's analysis that justice requires, then the onus is on us, based upon your paradigm of why the rent was, the escrow was higher than what rent should be.
that's my paradigm. Look, had this case gone the other way, and they would have reinstated the mortgage, or done whatever. This had gone the other way, then the Logans would have owed money on that. They would have had to make that up in some way or reformulate it in some way. They would have had to do that. So I don't know that this is an unusual paradigm, as you call it, that I'm asking. I'm saying you didn't go that way. So, in effect, the tenants are suffering, they have to pay rent. What is that fair rent for that period?
Well, but Judge, if we had been successful, we would have been entitled to all the money back because they weren't the owners.
Right, but somebody else would have been asking for the money.
Well, we would have been.
Is what I'm saying. What I'm saying is, yes, you would have gotten the money back, but there would have been somebody out there saying, you know, this mortgage, you now got to bring this mortgage up to me, or do whatever. So that money, yeah, it would have gone into your client's hand, but then it would have gone someplace else.
Well, absolutely, and that's why it goes back to what justice requires.
Okay,
But under your analysis, Judge, under your analysis.
there, you can sit there and you can try to formulate the argument for me. I told you what I want to see. Do you want an opportunity to get that? If you
Short
want
answer.
an opportunity to get it, I will give you that opportunity to get that. But I think you need to know that's where I'm coming from. What I'm saying is that the escrow was put into place in essence to maintain the status quo.
And I understand that, Judge. And if you could see what I'm doing, you'd see that I am trying to see if I can find, you know, such documentation. Having said that,
I will give you time to do that. I mean, I don't know why this was a surprise argument. I mean, I'm not buying Mr. Sheriff's argument any more than I'm buying yours in terms of what's been lost, what's been anything. It really is the Tenancy Act suffers. It's like, why don't buy plaintiff's tax argument? Because had he owned the premises and he's renting the premises, he would have to pay the taxes anyway. So that's not really a loss to him. He's just got to pay the taxes. I mean, to the extent anybody thinks that taxes are a benefit. But, I mean, it's just something you got to do. Here, Mr. Sheriff, your client has his hand raised. I don't know if he wants to address the court.
Judge, I would love for him to have that opportunity.
Well, not your client, your Mr. Plaintiff.
Mr.
Am I allowed to? I didn't know if I was allowed to.
Oh, anybody can say whatever they want at their own peril, so you go ahead if you want.
I just Googled to answer your question. I just Googled what the average rent in Ypsilanti is. And the first thing that came up is something called Rent Cafe, and it's $14.37 for an 873 foot square foot apartment.
Yeah.
Oh, all right, sorry.
No, it's okay. I'm just saying, everybody Googles it. I live it every Friday, so I know what the average rent's here.
All right.
Okay.
All right, sorry.
Yeah, no, I get you. I appreciate it, but. Mr. Fair, I will give you an opportunity to get that to me, because otherwise. Mr. Lowe, you wish to address the court. Go ahead.
I don't know how to start all this because it's something new to me, okay, for one. And
Say again, you
I
need to
said-
speak up.
I don't know how to say what I want to say because this is something new to me. I never encountered this incident. But
Okay.
at the beginning, this house was mine. And at the time, it was only $1,100 I had to pay for mortgage.
Right.
Then it ended up going up a little, not much, okay? So with that being said, I did everything in my best interest to try to take care of it to my standards, okay? Due to the fact that I got into this situation, I tried to uphold my part as a man and do what I had to do. All right, I'm sorry for whatever this is going on here. You know, I feel that I did everything. I voluntarily moved out of the house knowing what the outcome was. I left this house in good standards because I've been there 25 years at that time. I did not do any damages or anything. That furnace, during this time, it went out. I purchased the furnace at that time. Knowing the outcome of what happened, I felt that it was my furnace. I didn't do anything damage to nobody else's stuff. But as far as in this went. Yes, sir.
So that you can understand.
Yes.
Hey, I'm not blaming you for any of this. I'm not trying to, I hope you're not taking it that way.
No, sir.
All right. Your attorney, it's sometimes I just get great joy in the other. Okay. Okay, so don't, but it's not you. All right, at the time that I said this, so that we can be real clear,
Yes, sir.
I told you what needed to be paid.
Correct.
You in good faith. Okay,
Yes, sir.
so I have no qualms with you. As it went through, you're basically appealing a decision. And you're going through it. We see something like that on the national stage where somebody wants to pay less than, but whatever, okay?
Yes.
You did that because that's what's required. You're required to pay a bond in essence while you're appealing.
Yes, sir.
Because I don't know what the outcome's gonna be. That case really isn't before me necessarily, right?
Yes.
It goes through the process. And so that everyone is clear, and I try to make it clear at the time that I'm setting it. I have a number of these cases that when it goes up, I'm setting that amount. And sometimes I'll use what the mortgage payment would be. Sometimes I use what I know the rents in that particular area are. I'm looking at information. I mean, I'm not this number doesn't appear out of the blue for me.
Yes.
Okay. And so I set it with the idea that quite frankly, you're getting use of the premises,
Yes.
just like you would if you were renting. I get it, that for you, you're not looking at it as renting because it was fun.
Yes. It started off.
And I hear you. I get it. But then when all of the courts have spoken,
Yes.
it's not yours.
And
Because
that's
they belong to somebody else. Agree, disagree, doesn't matter, that's where it's going. And so then the question becomes, okay, you've had use of this that the courts have said belong to somebody else for some period of time.
yes.
All right. We don't get use of things in this country without paying,
Correct.
right? So now that's what I'm looking at using this money. Got it?
Yeah, I do.
Okay. But the long and short of what you were saying to me at the beginning, I have no fault with you whatsoever.
Thanks, sir.
None,
Thank you.
none, you know. So that you can understand where I'm coming from, everybody, and Mr. Council on this note. that during the housing crisis in late 2000s, I was handling every one of these cases. Like, why do people lose at all? Like, why do people lose everything that they work for, that they have invested in paying? And I presided over those cases. And, you know, some folks that they lost their home still couldn't get themselves back. I mean, they couldn't even pay them. Right?
Yes.
The fact that you did, like I said, I have no fault with you. I don't have any fault with Plaintiff for doing what he can do in this market in terms of purchasing a home. I have no fault with any of it. All I'm trying to give everybody an opportunity to get everything before me. And try the best I can. That's all I'm trying to do.
And that's why I leave it best in your hands.
So, Mr. Fair, here's what I'm gonna do.
Your Honor, before,
What's my next day? Hang on.
March 19th at 9 a.m.
Judge, can I make a statement first?
You wanna make a statement?
Yeah, because I went and looked, and I could be wrong, but I gotta confirm this. That I'm looking at a document that says his regular monthly payments for the mortgage was only $1,250 a month. And if you multiply that the 25 month, then just from those numbers alone, he's entitled to $3,750.
Okay. Submit that to me in writing. I'm gonna take all of that into account. Like I said, I'm just gonna make the best call I can. And either one of two things happen, but it's how my life is. Either everybody's gonna walk out of here, they're gonna be upset with me, that's okay. Or everybody's gonna be happy with me. Chances are everybody's gonna walk out upset, that's fine. That's how I live my, all right? So I will give you 2 weeks to get that information to me. I will adjourn this matter to March 19, 2024, 9 a.m. I've read over everything that you sent in. I don't need a whole lot more. I think I laid out how I am trying to analyze this. I will take into account the mortgage payments that he was making because that was kind of my basis for when I was setting the thing. But I'm gonna take into account that it's kind of increased. So I mean, I'm just gonna do my best math. But the reason I became a lawyer is because I'm not good at math, so I'm just gonna do what I can.
Same here, Judge, same here.
All right. We'll see you guys on the 19th.
Okay, thanks, Judge.
Thank you, Judge.
you.